conference and job fairs. So this event was held by NECINA and Lieping, North America. Today's agenda will be built by 5 sectors from 9 a.m. to 11:30 a.m. The first event will be opening remark. We will introduce briefly NECINA and Lieping North America. The second sector is the keynote speech. We will have lawyers to introduce us the immigration law speech. The third sector is the roundtable breakout sections. We have 5 industrials roundtables. Feel free to join each one you like. The fourth is the career sections for youth. We aim for MD sections for high school students. The last sector is the employee boost. So now let's welcome Lieping overseas to introduce themselves. Welcome, Gary Yu.
Hi, good morning, everyone. I'm Gary Yu, President and CEO of Lieping Overseas. It's my great honor to organize the Career Conference jointly organized by Lieping Overseas and NECINA. This conference, co-hosted with NECINA, has been an annual event since Lieping Overseas was founded in 2016. Through this kind of charity career conference, we can work together and bring successful experience to our members, young professionals and students, bring benefit to the workplace and giving back to our community. This year, we have invited many senior professionals, career consultants, and excellent company. We hope all of you will be benefit from that. At the same time, we also hope you will continue to support us and make this annual career conference better and better. Thank you very much.
Thank you, Gary.
Welcome.
So now we're going to introduce NECINA. We will have our Director of NECINA Career and Professional Department, Claire, to introduce NECINA. Welcome, Claire. Claire, I think you unmute. You still mute yourself.
Oh, I'm sorry. I'm sorry, everybody, technical. Thank you, Florence. Thank you, Gary. Good morning, everyone. And thank you for coming back for our conference second day session. Career Conference has become a signature program for NECINA since it started 7 years ago. And this year, we have the privilege to co-host with Lieping Overseas. NECINA stands for New England Chinese Information and Networking Association. It was founded in 1996 by a group of successful entrepreneurs. NECINA serves as a platform for our members, volunteers, sponsors, and partners to network and build long-lasting professional and social relationships. It also brings professionals at all ages to learn and embrace our technology, promote innovation and entrepreneurship, and enhance career and professional skills. Our programs primarily consist of technology, entrepreneurship, and career and professional development. You can find these specific programs on this slide, and also please visit our website for more details. Today, we are very, very excited to have Yaren Pan, a well-known local immigration attorney in the New England community. Through past over 20 years, she has built a successful practice, and today she is going to share with us her insights on current immigration conditions. Please join me and welcome Attorney Pan. Thank you.
Hello. Let me open my. Okay. So hello everyone. I'm so glad to have this opportunity to share some immigration news, share some policy changes, aiming to helping you arrange your career and arrange and plan your career in advance. Yes, just a few words about myself. My name is Yarin Pen, immigration attorney. My office has been contribute to immigration law for past 20 years, and during which we have helped thousands of our clients working and immigrant in the USA successfully. So 我这边好像有点问题去，你看啊，我这边好像有点翻不了篇儿。Oh, okay, that's fine. That is just our office introduction. Okay, today my talk will be divided by 3 topics. The first one, I will share with you some immigration policy and law changes since COVID-19. The first one I would like to point out, currently no immigrant visa application is available. Based on USCIS and the DOS, the latest update, currently consulate office is focusing on immigration and K-1 visa applications. After that, they will shift their effort to F1 student visa applications, and then, shift their effort to non-immigrant working visa applications. That is H-1B, L-1, and the J-1, etc. So please, make your wise, apply before you are going to go outside of the USA to make an international trip. Also, I would like to point out, currently the travel ban has not yet lifted, which means if you pass, 14 days, you visit or stayed in China, you cannot directly re-enter into the USA. You must find a qualified country to stay there for 14 days. Then you can go re-entry into the USA. Another one is in relation to DOL, prevailing wage related policy change. DOL, has already has the fixed plan to raise the salary and change its prevailing wage the policy. But that policy has been postponed for 18 months, which means, prevailing wage related policy change will go in fact next year, November. That is good news, for H-1B the beneficiary, perm the beneficiary, as well as employers. And also, I would like to point out, that is good news for most of I-485 applicants. Right now, when you file adjustment of status application, you do not have to add form I-944. That form is called as public charge form. So you do not have to edit that form in your filing package. That is good. And also, it's a very important policy change, made on February 22nd. That is very important, benefit a lot of the students, which means, during COVID-19, USCIS dramatically delayed its operation function. Some students, when they file their OPT application, after 3 to 4 months waiting period, they just got the rejected package because, they made a wrong check, or wrong address, and eventually got the rejected package. But now USCIS, relieved, that detrimental effect and said, if you meet the following criteria, you can refile the application, which means, if you file the case and that application was received by the USCIS, on or after October 1st, 2020, and USCIS subsequently reject that file, and you can refile, before May 31st, 2021. Certainly, indeed, you must meet, certain criteria, filing timeline criteria, which means, I will touch that timeline criteria or when I focus on my topic in F1 the category. And also, the good news is, recently, based on USSS, updated policy, students who are going to file OPT, they can file OPT online. That is very good, beneficial to our F1 student, as it can avoid the wrong check, wrong mailing address. Okay, now I think I'm going to shift my topic to some important issues need to be addressed in relation to F1 student the status. The first one I would like to point out, because our office always always take the calls, ask for when can I apply for the OPT. Several deadlines you have to keep in mind. The first deadline is, you can apply for the OPT 90 days before your graduation or 60 days after your graduation. And also you should keep in mind, there is only 30 days, validation period of a newly issued I-20. It's also called as DOS recommendation, updated in your service system, just a 30 days, validation period of time, which means, you have to USS receive your application, OPT application, within, the deadlines, several deadlines. Also, I would like to address, last year when USS, adjudicate cap related H-1B application, USS issued a lot of RFEs, not in relation to specialty, just in relation to status maintenance. USS, such as, USS requests, entire pay stub from the very beginning of the employment until the issuance of the RFE. Also, if there is no pay stubs, for example, the first OPT, you do not have to be paid, but you have to acquire employment verification letter, verify your legal employment under the OPT. Also, USS asks for the product, USS will check whether or not the product is linked between your major and the work. For OPT, for STEM OPT, the extension, same as the regular OPT, or also called as post completion OPT. The earliest date you can file STEM OPT the extension is 90 days before the regular OPT the expiration date. And also when USS received, your STEM OPT the extension application, you can legally work for another 180 days with the receipt. Some students ask for, if he or she hits the H-1B the lottery, whether or not, they need to extend to file STEM OPT the extension. The answer is yes. You must prepare the RFE, H-1B the RFE, or H-1B the denials. So timely file your STEM OPT the extension. Same as post-completion OPT, last year, USSS issued a lot of RFEs just in relation to status maintenance. So please prepare and keep all evidence. Frequently asked questions related to OPT the status. Some students ask for, if I'm going to transfer my transfer to another institute, or if I'm going to pursue a higher degree, but my OPT is still invalid, do I have to stop my work immediately? The answer is yes. Can I attend a company's training per section if I do not have a CPT related item in hand? No, answer is no. And if OPT is denied, can I continuously legally stay in the USA? Not really, not really. And also, I would like to point out, and have your attention in relation to I-9, the I-9 related policy. since last March, USCIS lose, the requirement for the I-9. Currently, if you just have approval notice in hand, but you do not have received the real EAD card, you still can legally work in the for the US employer. Do not have to wait for the card. And also, USCIS just updated and extended another 2 months until May 31st, for the I-9 release. But these 2 months just for employer with a remote working policy. So if a company has already resumed, normal working function, you do not have to enjoy these 2 months. And okay, let me check. Yeah, can I? Okay, can I raise? Okay. Sorry, I missed it. And the general questions in relation to F1 reinstatement. So the commonly used for F1 reinstatement is in relation to, I-20 outdated for no more than 5 months. And you abide by all requirement, for a good faith student, such as, you paid tuition, took a regular course of study, since, etc. But some students, have experienced mental depression-related problems. So if your doctor could give you a verification letter and verify your mental-related problems, even though your I-20 has already outdated for over 5 months, you can still apply for the reinstatement. OPT is denied. If OPT is denied, you cannot, in general, you do not have any chance to apply for the reinstatement. A proposed rule by ICE for I won't mention that, maybe won't be implemented. Okay, now I will shift, to H-1B, the topic, some update on H-1B and the related regulation, plus some inquiry and answers on H-1B, the field. So first and foremost, I think, most of the students has already know, since calendar year last year, USCIS initiated, electronic H-1B electronic registration policy. And last year, the selection rate is around 50%, but this year reduced to 30%. But anyway, last year, in August, the USCIS, initiated a second round selection and estimated 10%, actual, I think 10% and actual, will be added to overall the selection rate, for master degree, And also, I think everybody know, since last June, based upon President proclamation, people holding H-1B, L1, J1, cannot, if they are not, in the United States, they cannot apply for the visas. And just like very beginning, I point out, right now, consulate office just won't focus on non-immigrant working visa application related visa applications. So please do not go outside of the USA without the policy resume. Another question always be asked for, by a young professional of H-1B is that, they know they have, they enjoy 60 day grace period after being laid off. But how many 6 days they can enjoy? My answer is, you can enjoy once during any single authorized validity period, which means, if you just got laid off, you got the new company's H-1B approval, then you got another layoff, you can enjoy another 6 day period of time. Another last November 17th, USCIS, updated its policy and authorized USCIS officer, more authority, more discretion to when they adjudicate I-485 application, which means, when they make a final decision, approval case or denial case, they can base upon whether or not the case approval is in the best interest of the USA, which means, please keep your non-immigrant legal status without I-485 approval. Also, several sentences, addressing fan dream issue. Many students has already know the fan dream and the signal contact. These two companies were founded by Kelly Huang, who was committed, the visa fraud and was already sentenced to jail. But a huge impact, on students. So any students, all students who previously nominally work for these two companies, USCIS will deny their STEM major extension, STEM major OPT extension, and all kinds of H-1B, the petitions will deny all kinds of H-1B petitions. And even though you married with a U.S. citizen, without a qualified excuse for qualified excuse for the waiver, which means extremely hardship waiver, it's very hard to meet this criteria. Your adjustment status will be rejected. Will be denied because you made a false statement. That is a huge defect. So let me shift, the brief answers, to frequently asked questions. If I was laid off, and I cannot find the job, within 60 days, 6 days grace period, how should I do? Based on USCIS latest, latest AILA and the USCIS latest policy updates, you can file B2. That is a very good bridge. File B2. If another frequently asked questions is, if I transfer to a new company and the new company initiated H-1B application and got approval, but I changed my mind, I do not want to go there, to go to the new company. Whether or not the new company has any legal authority to claim some compensation from my side, answer yes, law support. The new company is could claim, the attorney fees plus, reasonable cost generated during recruitment process. Yeah, that's fine. Sometimes, my clients has already compensated the employer over $10,000 if they change the mind. Okay, another question is, if I go to work for the new company and the previous company didn't withdraw my H-1B, then I change mind, I would like to go back. A previous company, is that okay? Okay. Does the law permit STEM OPT the student work for multiple employer? Answer yes, but all employers must be STEM must be e-qualified companies. What else should I pay attention during OPT period? Just mentioned, please keep all record, such as payment record, employment verification letter if you do not have a payment, and also work product, in case later when you do H-1B petitions, USCIS asking for that, issue RFE for requesting those mentioned evidence. Yeah, the last one, I think, some students, some young professionals ask for, okay, currently I'm working for nonprofit, but I find a job, from a for-profit company. Can I work for the for-profit? Yes, but provided you must, in the meantime, work for the nonprofit and then qualified you for the for-profit. Certainly, indeed, the for-profit company has to apply for the H-1B. But if you hit the lottery and eventually your H-1B is approved, so you do not have to work in the same time for the nonprofit, after October 1st. Yes, the last one is one question. The last one question. We just got a lot of calls, I want to file I-45 application because, my PD priority date has a 4 weeks in B chart. So always check, USCIS, the update. If USCIS permits you use B chart to file adjustment status, use that. If USS doesn't permit your use B chart, do not file the I-485. Thank you very much.
Thank you very much, Lawyer Pam. Can you, those are really, really insightful information for our international students, which I really appreciate that. I think some of the audience also really appreciate that too.
Thank you.
Mm-hmm. Could you stop share your screen? Then I can share my screen.
Sure.
Thank you. So now we have the next sectors for the roundtables. So we will have 5